All right. I did 3 test live streams today to make sure that whatever's going on with the snow and everything yesterday isn't going to happen today. Nothing went wrong. So I hope you guys are doing well. Um, the snow is pretty much, I mean, it's still outside, but it's pretty much gone here today. The rain washed it all away. And now it's just cold. It's just supposed to be a lot colder. It's supposed to be a lot more snow. I mean, I saw earthworms last week. It rained last week. And I saw little baby earthworms crawling on the cement trying to get away from the water. You shouldn't see earthworms in Pennsylvania in January. You just shouldn't. But, we did get some snow. Maybe it'll get more. Maybe it'll get cold enough for, you know, the earth to do what it's supposed to do during the winter. All right, we're going to start off great because we haven't been to Mechanico in a while. We haven't seen Steve Vincent and Phil Reagan go back and forth for a while, and I miss them. So, this case isn't anything to write home about, but we just miss them. So we're gonna play them real quick. Here we go.
2 million dollars.
Oh, okay. Wow, okay. 1 second, please. Okay. Argument.
Yeah, Judge. This was a New Year's Eve. You know, I don't know, Mr. Moore. Judge, probably this was a New Year's Eve celebrating a little bit. Now, this is a person, Your Honor, the complaining witness that he's obviously known for a while. Has had a intimate. Well, I don't want to say intimate, but has had a relationship with. He has keys to her house. And even she said it in the report. So this was a situation on New Year's where he, came over to the house, was waiting on her to get back. I'm assuming he might have had a cocktail or two, and she came home eventually. There was a situation where I believe that a phone was involved. Going through the cell phones, we talk about, that's probably not the best thing to do or want to do. But sometimes when you're drinking a little bit, and you're getting your feelings, sometimes things happen, Judge. But I do want to point out that, it was a time once the phone situation got resolved, I guess, to a point, there might have been, excess, contact between the two parties. Now, it says that the complaining witness came out of the house and got into the car with Mr. Moore. So it tells me that they, she wasn't trying to get away. She got in the car. He was going to take her to the hospital, allegedly, she says. But then the car went another direction and it came back to the house. And as the report reads, she, passed out a little bit. I don't know if she had a couple cocktails. I don't know. I just know that, Judge, she awakened. She was going in an EMS. But, Mr. Moore was the one, I believe, Judge, that contacted the EMS. She was kind of out of it. He even followed the EMS to the hospital. So it wasn't like he, trying to.
He kind of like was the arsonist who threw the gasoline all around and lit the place on fire and then called the fire department to.
Well, I don't know. I don't want to put it like that because I don't know.
That's what it kind of sounds like, though. From the allegations, he beat her allegedly because she wouldn't let him see her phone. He finally gets in the phone and finds out that there's nothing in the phone. and he allegedly feels guilty, and so he's going to take her to the hospital after his beating, but then somehow they U-turn it out, and then they get back. She passes out allegedly from the beating or whatever causes her to lose consciousness, and she's waking up. She wakes up to intercourse. That's the allegation.
That's the
allegation.
Yeah, that's the allegation.
That's the allegation.
Allegation.
But we can't give him a lot of credit for he was going to follow the ambulance after he beat her, though, allegedly.
That's part of the allegation, though, Joe. We got to give him. I think that's important, because if you do one part without the other. If you want to go with the beatings and all that,
no, I'm saying he did it. But I'm saying we're not going to make him like a gentleman for following the EMS after the alleged beating, because she was asleep at home. So it really shouldn't have been a lot of EMS.
He called the EMS, I'm assuming he called, because she said she's awakened in the EMS. So somebody called the EMS. Right. So maybe, she felt uneasy. I don't know, Judge. I don't know if they made up. They had, I don't know what happened. I wasn't there. I just know that the prosecutor, in order to make a case, has to write it up a certain way. And this is how they wrote it up. They're trying to get probable cause. But I'm saying, Judge, there are certain factors that are a little confusing. You know what I'm saying? So I'm saying that it's probably like the court says, jealousy gone wrong. And now, I think separation is a good thing. Right now, he has key to the house. This is not a random situation, Judge. I don't want you to think Mr. Moore goes out here randomly. This was an isolated situation. I think drinking got out of hand and jealousy maybe a little bit. But I think if you separate the two, put a tether on them, no contact, I think that would suffice. That would keep her in a situation. No alcohol. Put an alcohol tether on. No alcohol while this matter's pending. He has a good job, Judge. He has 4 children. He takes care of. He works, makes car parts. So he has a very good job, Judge. This is an unfortunate situation, Judge. And I think that it's isolated. I do think it's isolated. So I'm going to ask the court to reduce the bond, Judge, with no contact whatsoever, GPS tether and alcohol tether.
Okay. Mr. Prosecutor, make it quick, please. Thank you.
Sure, Judge. There are a lot of I thinks and I assumes, and this is random and this is isolated. If I could, Judge, just point your attention to the second to last page of the report. Mr. Reagan may want to do that as well in terms of whether or not this is an isolated incident. Previously, he set her house on fire. Previously, he ended up pouring gasoline on her and told her he was going to light her on fire. Previously, he ended up having a girlfriend of his point a firearm at this woman. The same woman who this defendant said, this time, I'm not going to jail. I'm going to go to prison because I'm going to murder you. So, I don't have any.
Court haven't heard. All right, court haven't heard. I'm sorry, Mr. Reagan.
No, I just don't have I don't know about any of the those particular items that Mr. Vincent is speaking of, Judge, but
Court haven't heard the arguments for counsel. Bond is currently set at $2 million cash. The $2 million bond is an unaffordable bond. Court finds that in order to have an unaffordable bond, there must be a showing of a danger to the community, danger to the complainant, or flight risk. The court will, I guess, adopt Mr. Reagan's argument that Mr. Moore is not a random person committing home invasions and CSCs, but that we do have a situation where, this is not quite the way to bring in the new year. Upset because allegedly upset that someone that or have a child in common is, I guess, not home and making assumptions of what she was doing, and wanting to get into her personal property. And because she won't allow you to invade her privacy, it leads to situations that, they are what they are, and that will be litigated at a next step. And so right now we're only dealing with bond. So court does find a $2 million bond to be excessive. Court is going to reduce the bond from $2 million to $500,000 cash, no contact with the complaining witness, GPS tether, house arrest, and an alcohol tether. Thank you. And just a bit of advice, Mr. Moore, you should, hold your phone sacred and you don't have to let anybody get into your phone. That's your phone. And other people's phone, unless they're your children, you don't have a right to, ask or, to get into someone else's phone because that's their phone. It's their property. And we have to kind of respect each other's properties as adults. Now, children don't have the same rights of privacy with parents, but adults do have the right to, their phone. So just a little tip in the future. Have a good day, sir. What was the case? Mr. Wood, I see his attorney's here. You can recall that case, please.
So we get a lot of cues from McConico when he's the judge.
Recall the case number.
So the first one is after Philip Reagan does his excellent stuff, which we all hate, but he does it really well. If McConico says, all right, let's hear from the state or the city or whatever he's in that role that day, make it fast. If he says make it fast, he already has his decision and it's going to be in Vincent's favor. Like, he's already ticked off at this person. And he doesn't want, the state to talk too much because he's ready. And usually then he doesn't even speak to the inmate. He just, bond remains. Goodbye. And that's when he's really mad. This one, though, he did both. He said, make it fast, so we already knew this guy was in trouble. Then he spoke to him about his cell phone, which shocked me. I didn't think he was going to do that, but he has to get his words out in some of these. Sometimes he's just too mad. That's it. It's over. Other times he does get his words out, but he doesn't say make it fast when he does that. He mixed it up today. Let's see where we're gonna go next. Okay, so I don't always get the videos that I get from YouTube. Some of them I get right online from the court's live stream, and you can't rewind that. You can't go back to the beginning if you miss it. So I only got a piece of this, but I got the best piece of this. I think we're going to Indiana.
Did he ask for a public defender on that case?
He was in court, I believe, the 21st or for the bond. He indicated he would be trying to hire private counsel.
Oh. But if he couldn't afford to hire a lawyer for an F5, what makes you think you're going to hire a lawyer on an F3? A more serious offense.
I can get a lawyer, ain't the problem.
Well, you didn't get a lawyer for this case. It was just a convenience for you. You didn't hire a private lawyer on these two cases. We were here in November, we set them for trial.
I thought the case wasn't needed for
But sir, the public defender is not a convenience for you, or what do you think these lawyers do? Do you think they don't go to law school? Do you think the public defender doesn't go to law school like any other lawyer does? Do you think they go to Ivy Tech and it's kind of vocational? So if you can't afford a lawyer, sir, why didn't you hire a lawyer on these cases? I don't know either, but I'm going to confirm the trial. If you want to see if you can work something out, fine. Otherwise, we go on to trial. You are, let me see, let me look at the older case first.
Right.
29th. Yeah, we got plenty of time. We got 3 weeks, so 29th is your next trial date. Is your trial date at 10 o'clock.
And we would also be confirming for the trial date starting up.
Sorry?
His second trial would start February 1st, according to the calendar.
Okay.
So we'd be confirming for that too then.
Yep, we're confirming for both. You're both set for today. It's the 29th and the 1st. See you then.
Okay. Thank you, Your Honor.
Yep.
He's going to trial on the 29th, and he doesn't have a lawyer. He has a couple other cases where he took the public defender, but on this one he keeps saying since November that he's going to hire one, and he hasn't. And this judge just stood right up for the public defenders everywhere, and a lot of them. Okay, let's not talk about Butler, guys. Let's not bring Butler into this conversation here, all right? But most of them are outstanding and they work hard. And, people treat them like, like, the macaroni and cheese you get, the generic brand that's really, really bad. That is not how a public defender is compared to craft. Public defenders are craft, they're very good. All right, we're going to go to, I have no idea what state. Connecticut? I might be going to Connecticut. But this guy's just funny the whole time.
Oh, good.
Yes.
No, this isn't Connecticut at all.
Good afternoon, Mr. Thomas. I'm Judge Schultz. Can you hear me?
Yes, I can. It's
Okay.
cold in here.
I'm sorry to hear that. You're not the first person that said that, so I'm guessing it probably is cold in there. It
Yeah.
looks like you have pending a possession of paraphernalia that was alleged to have occurred November 9th of 2022 in the area of North 82nd and State. There's also an interference with an officer that was alleged to have occurred January 7th of 2023. And then it looks like you received 2 different failures to appear. Looks like you received one January 24th of 2023 in the area of 7552 State Avenue, and the other May 2nd of 2023 in the area of 555 North 78th. And it looks like you also have a couple of cases that are in a bench warrant status. Give me 1 second to, I'm not in a bench warrant status, in a probation status. Give me 1 second to look over those. Well, Mr. Thomas, it looks like there wasn't a motion to revoke filed on either of these. So we're going to go and they're out of time to file one. So we're going to close those. So that'll be, we're closing 623153 and 623152.
Excuse me.
So right now, your bond is set at $2,750. Are you requesting a reduction in bond?
Yes, ma'am.
Okay. Is there a specific amount, or are you asking for
Under 1,000.
Okay. And what is the city's position?
Ah.
I'm
Wow.
asking Mr. Rankin.
I think the city
okay.
would be okay, yeah, with reducing his bond to probably $200.
I'm sorry, you said you would be comfortable with, I believe you said $200?
Yeah.
Is that correct?
It looks like, the total fines for the charges don't add up to all that much, so
Mr. Thomas, what's your position on that bond? Are you able to make that bond?
Not right this moment. If I get an OR, I'd really appreciate it, and I can get it all in one lump sum. You know what I mean? Instead of here go 20, here go 50. I'd rather just get it all in one lump sum and then be just done with it. That'd make way more sense to me. You know what I mean?
Okay, let's give Mr. Rankin an opportunity, because earlier you had not requested an OR bond. So, Mr. Rankin, what's the city's position?
Judge, I think I wouldn't object to an OR bond.
Okay, so I'm going to give you an OR bond. You'll need to appear in court Monday.
Give me an OR bond.
Yeah.
I know, man. You don't care about nothing but yourself.
Monday, January 8th.
I'm just excited that they're giving me an OR bond. That's all I mean.
Mr. Thomas, you're going to miss court if you don't pay attention to what I'm telling you.
Yeah, I know. I was arguing with the officer because
So-
they're giving me an OR bond. I'm very
We're
fortunate
going
to have it.
continue this to January 8th at 1 p.m. We'll send that paperwork over to the jail when we're done our entire docket. So it'll still be a few more hours before you get out. When we send the paperwork over, they give you a copy. It shows the date, time, and location. So January 8th at 1 o'clock at City Hall. If you fail to appear, the judge could issue a bench warrant with a no bond hold. So please make sure you appear in court Monday, January 8th at 1 o'clock.
I will.
All right. Thank you.
Thank you. Hey, so ma'am,
Yes.
I will be released today from Wyandotte County.
Later today.
Yes.
Yes.
All right.
Thank you. Oh, they probably need to get the headphones.
That's like Neville Longbottom running away from with the sorting hat still on his head. He was fighting with him right there. That was Kansas. It's not Connecticut. I was wrong. But I didn't see him anywhere at 1 o'clock. I looked, and I couldn't find him anywhere at 1 o'clock today. So we'll never know. We'll never know what happened to him. All right. Now I really think we are going to Connecticut. I do think so. And this judge, this is the first time I saw him. He is great.
All right, so 46 DO4 2311 CM 3064. Last name should be Gaber, Geber, correct? So we need to have a clerk fix that.
No, I think it's Indiana.
You do have the home breath? No, you don't.
I do right here.
What's the non-compliance filed on December 22nd?
Your Honor, it looks like it was alcohol violation with the highest reading of 0.085 on December 25th.
Apparently my orders don't apply to you either, huh? You have an alcohol violation on your home breathalyzer of 0.085 on Christmas. Ring a bell?
I do remember this saying violation or violated.
Ring a bell? Remember Christmas maybe?
Yes, I do.
Yeah, had a few drinks, did you?
I did.
So my order doesn't mean anything. Judge Friedman's order doesn't mean anything. You can do whatever you want. Right?
No.
So what's the point here, Mr. Gaylor?
That I am trying to get my life back together.
Well, you're not doing a good job of it now, are you?
Not right now, I don't think I am, because I'm here on a matter that has been continued since summer, and then
So that's my fault it's been continued?
No.
What's your point?
That I'm here trying to resolve my matters and have not any legal matters that I have to.
You got arrested around November 27th, 26th through 27th, right?
Correct.
You went to court on the 27th in front of Judge Friedman, and she told you a condition of your bond was a home breathalyzer. You paid your bond, or someone paid it for you. And approximately a month later, you violate the conditions of your bond. When you already violated the conditions of your bond from this case in 2307, CM 1789, when you're out on bond, one of the rules is you're not supposed to get arrested for any other offenses. So apparently your conditions of bond don't mean anything. You just do whatever you want. Well, how else am I supposed to interpret that? Who's here with you today?
My mother is right here.
You're making her proud today as well, huh?
Mom's not safe right now, guys.
What's your mom? What are you saying, Mom? What am I supposed to do with your son?
I'm sorry?
What am I supposed to do with your son here?
Oh, he needs alcohol classes. He needs to keep his job.
So why isn't he in those classes?
Pardon me?
Why isn't he in those classes?
Why isn't he in them?
Correct.
It's not voluntarily. I think it would have to be forced. I don't think it was ordered yet, was it?
Why wouldn't your son go to alcohol classes on his own if he needs them?
I'm not sure. I've asked him, before to try to get help. I do know that since he's been on this breathalyzer, he had one violation.
No, you don't understand. Both of you don't understand. There's 0 violation tolerance.
Yeah.
It's not just he just had one violation. He knew what he's doing.
I'm sorry?
He knew what he was doing. He knows what the requirements are. And he violates because he doesn't think anything's going to happen to him. You can go to jail, Mr. Gerber. Remanding you to custody of the Port County Sheriff.
Just like that.
Gerber, I'm going to reset you to January 10th, 2024 at 12:45 p.m. I would strongly suggest that you have a plan in place that you're going to tell me about on Wednesday about what you're going to do to take care of your problem, what you're going to get, program you're going to get yourself into, which sounds to me like you need an inpatient program. You better have a very specific and thought out plan. Do you understand that? Otherwise, you can sit in jail. State of Indiana versus Jordan Glade, 406004, 2201 CM 190, 2306.
So that was very Judge Webster of him. Like, he asks a question, and then you know how Judge Webster just sort of sits there and stares at a person with that sort of smile on her face and doesn't say a word and just sits there? That's what he was doing. Except, like, his bark is not bigger than his bite. His bite is big. He said, that's it. You had a drink of alcohol on Christmas. You're going to jail. That's we see people who have violated over and over and over again get another chance, another chance, another chance. And this guy had one drink or two, I don't know. He was close to the legal limit on Christmas. And that was the judge sent him right to jail. We're not done with this judge today because he was great. So I got more than one. Let's see. Okay. What I want to know with this next one is if anybody can pick out a violation she did not break. Is there any way of her bond that she did not violate while she was out? Let's try to pay attention and see. I know this, I love this judge, so let's not hate on him. He's very monotone. But I love him. He's great. So we're going to see if we could figure out any violation that she didn't hit.
The record on the January 3rd criminal traffic docket recording on the VIQ application. Officer, who do you have with you?
Your Honor, this would be April Irene Adams.
Thank you. We have two cases, both captioned State versus April Irene Adams. The first is CLW 2024 CR1, which comes on for first appearance on a one-count complaint, and the second is CLW 2022 CR 56, which comes on for hearing on an affidavit of violation of probation in a misdemeanor case. Ms. Adams appears in person in custody by Zoom, and State appears by Ian Audi by Zoom. Ms. Adams, do you have a copy of the complaint in the new case in front of you?
Yes, sir.
Does your correct name appear on that complaint?
Yes, sir.
Is it correctly spelled?
Yes, sir.
I'm going to go over the one charge in the complaint so you know what you're charged with and the possible penalties which could be imposed if you were convicted of that offense. Count one alleges that on December 24th, 2023 in Cali County, Kansas, that you obtained or exerted unauthorized control over property worth at least $1,500, but less than $25,000, being a 2005 Chevy Tahoe, keys and the Kansas disabled tag, and that you did so with the intent to permanently deprive the owner, Michael Paul Kennedy, of the possession, use, or benefit of that property. That's known as theft. It is a severity level 9 non-person felony. That is an offense for which, if convicted, you could be sentenced to the custody of the Kansas Department of Corrections for a minimum of 5 months to a maximum of 17 months, and you would be subject to a possible fine of up to $100,000 in post-release supervision for a period of 12 months. Do you understand that charge and the possible penalties?
Yes, sir.
This is an offense for which you are entitled to be represented by counsel. That is a right you can waive. You can also ask the court to give you time to hire an attorney of your own choosing, or you could ask the court to appoint an attorney to represent you. Do you know how you want to proceed with regard to your right to an attorney?
I need a court appointed.
I believe Matt Metcalf is who is representing you in the other case when it was resolved. Is that correct?
Right.
I'm going to appoint Matt Metcalf to represent you in this case. He will be advised of that appointment and provided with paperwork so he can prepare to represent you. Let me now go over in case number CLW 2022 CR 56, the allegations of probation violation. Have you seen that affidavit, ma'am?
Oh, no, sir.
Okay. This is a affidavit filed by Court Services Officer Ashley King. It alleges that on August 10th, 2022, you were granted 1 year probation from a sentence of 1 year in the county jail, and that on October 3, 2022, an affidavit of violation of probation was filed alleging failure to report and use of methamphetamine, and that and that on November 30th, 2022, you admitted to allegations and probation was reinstated, and you were ordered to obtain a drug and alcohol evaluation. On April 19th, 2023, the current affidavit of violation of probation was filed. In that affidavit by Court Services Officer Ashley King, which I was reading from before, the allegations about the current violations is that you violated condition number 5, that you obtain and work faithfully at suitable employment, and that you violated that by failing to provide proof of employment. The next violation alleged is condition 8, do not possess or traffic in controlled substances, and it's alleged that you violated that condition in that you submitted to a UA on April 4, 2023, and the test was confirmed positive for methamphetamine and amphetamines. The next alleged violation is condition 16, that you enter into and participate in good faith and successfully complete any training, drug, alcohol, or mental health treatment or other counseling program deemed necessary by your court services officer. And it is alleged that on January 24th, 2023, you were directed to attend 3 self-help meetings per week and failed to provide proof of attendance to the court services officer. And the final allegation is that you were to obey all reasonable verbal and written instructions of your court services officer, and that you violated that condition in that on December 29, 2022, you were directed to complete 5 job applications per week and provide proof of applications to your court services officer, and that you failed to provide proof of applications. You also have a right to an attorney in this case. Would you like me to appoint Mr. Metcalf to represent you in this PV case also?
Is there a way I can have Priscilla by chance?
Okay, right there. Right there, that's where she lost me. Now I don't like her anymore. Metcalf is amazing. So Metcalf works with this judge all the time. And he's very soft-spoken. And, you know, he's not flashy like Phil Reagan or anything. But he knows exactly what this judge needs to hear to get the job done. And he does it great. And he does it every day with Iannotti right here. They're just a great couple. Thank you. But she wants Priscilla, which Priscilla is fine too. But why would you throw away Metcalf like that? But wait till you find out why. Why she can't have Priscilla. It's hilarious. Oh, and by the way, I caught one violation she didn't do. I'll tell you at the end if you didn't get it.
I'm sorry, what was that question?
Is there any way I have Jennifer Priscilla by chance, or, but if not, it's fine.
But wait, there's more violations.
Give me a minute here. I read the second affidavit of violation of probation. There's a third one, which was filed December 20th, 2023. And in that affidavit by Ashley King, it is alleged that you violated condition 1 by failing to obey all federal and state laws, municipal and county ordinances, and that you violated that, and that you were cited and released by Arch City Police Department on November 21st, 2023 in case number A23-15546 for transporting an open container, and that you failed to report this incident to your court services officer, that you violated condition 9, that you should not possess or consume alcohol, in that you were cited and released on November 21st, 2023 for transporting an open container of alcohol. Condition 11, you were to not voluntarily change your residence, employment, or telephone number without the express consent of your court services officer, and that you violated that condition in that you reported to your court services officer that you were residing with your father, and that your father reported to Officer Elizabeth Lyons that you were not living at that address, and that you violated condition 16, that you would enter into participate in good faith and successfully complete any training, drug, alcohol, or mental health treatment, or any other counseling program deemed necessary by your court services officer. It's alleged you violated that condition by failing to participate in good faith in your treatment program at Preferred Family Health, that you last attended group on December 5th, 2023, and last attended an individual session on December 1, 2023. And condition 18 was that you are to obey all reasonable verbal and written instructions of your court services officer. And it is alleged that you violated that condition, and you agreed on December 18th to a 3-day quick dip sanction for failing to participate in good faith in your treatment program, and were directed to report to the Cali County Jail on December 19th, and that you failed to report to the jail as directed, and that you violated this condition also in that you were directed to attend 2 NA-AA meetings and failed to provide proof of any meetings attended. Do you understand those more current allegations of violation?
Yes, sir.
In response to your request for a different attorney, I'm going to appoint Matt Metcalf in this case also, because it just makes sense to have
The same one.
one attorney in both cases. And I do not know the circumstances of Mr. Metcalf ending up being the second attorney representing you in the 22 CR 56 case, but I'm not going to reappoint Ms. Basilia in a case that she withdrew from.
That's fine.
Officer, what's the bond in the 24 CR1 case?
I show 3,500.
And is there a bond set in the PV case?
I show a no bond on it.
Would I be able to have a bond or?
Well, give me a second. Mr.
Okay.
Audie, what's the state's position on bond in the PV case?
I don't object to the court setting a bond, but I don't have a specific recommendation.
I'm going to set the bond in the PV case in the amount of $1,000 to be in the form of cash or professional surety. I'm going to leave the $3,500 bond in place in the new case. And I'm going to continue this matter. Give me a second so I can see when we're moving Metcalf's cases to this morning. I think the earliest he had any new cases set was, well, yeah. January 24th. We're going to continue these matters to January 24th at 8:30 a.m. The 22 CR 56 case will come on for admission or denial. The 24 CR1 case will come on for preliminary hearing status. Ms. Adams, if you're able to make those bonds, it will be a condition of your bond that you immediately contact Mr. Metcalf's office, make arrangements to confer with him and follow the directions regarding meeting with him, and that you appear by Zoom on January 24th at 8:30 a.m.
Thank you.
Anything else we need to address in this case? If not, that concludes this case. Both of them.
All right, do you guys know? Okay. It might be, you can't say one of the violations was she didn't pay her costs and fines, because that's a given. We know she didn't pay any of her costs and fines. But she hit every other violation except for one that I could see. And I think it was she didn't have a weapon. She didn't get busted for having a weapon, but she got busted for every other part of her probation. She didn't do any of it. Not only did she not do any of it, she picked up charges and charges and charges. And then she asked to pick her own attorney. Are you joking? Oh yeah, I'm a fall risk. That's I am every day. All right. That's what we should have had violation bingo, Jason. That would have been so much fun. Although taking a shot for every violation she didn't commit would be bad. So we should have taken a shot for every one she did do. Next time. Next time. Okay, we're going back into another courtroom, and like a nightmare scenario happens, and it's funny because if you can't see it, most of the people in the gallery raise their hand when the judge asks a question, and then a couple people on Zoom say, "Me too, me too." So let's watch. We're gonna see the last part of another case first, and then we're gonna get to the judge's question.
What days I put you in jail to execute these 2 days if you keep violating things. So you're either gonna have to find one of two things. You're either gonna have to slow your work down so that you can relax and get some sleep and etc., or you're gonna have to find a different way, a legal way to cope that doesn't violate your rules, okay?
Yes.
This is it. Do you have any questions about what I'm telling you?
No, sir.
All right, I would suggest strongly that you go meet Mr. Snyder or whoever you want to and get your attorney hired, get these things going. But again, if pretrial informs me of any alleged violations, I'm executing those 2 days. Right away, I'm gonna issue a warrant for you. Okay? Did you sign your rights sheet today?
Yes, I did.
You're gonna provide it to my bailiff, or you still at 220 Chapman Drive, apartment 801B, New Carolina?
Yes, sir.
You have a cell telephone number?
Yes, I do.
What's your number?
219-262-4229.
Now, I would strongly suggest you tell your attorney that you have 2 days of jail hanging over your head, and it hasn't been executed yet, but you've already been in trouble twice with the court, okay?
Yes.
All right, good luck to you, miss.
Thank you.
State of Indiana versus Marcus Davis Lewis, 46D04, 2304 CM 908, 2304 CM 1009. Show for the record, Mr. Davis Lewis appears in person without counsel. We're also here in 2310 F61516. Where's your attorney? I don't know why you're here. What do you have? Paycheck. You hired Mr. Paycheck? Yeah. Who else has Mr. Paycheck today? Anyone else? 1, 2, 3, 4.
Everybody. He's counting them.
I do.
Mr. Khan, Mrs. McMillan has him.
Ms. Coleman does too. I believe Ms. Coleman on Zoom also. That's Mr. Paycheck.
Ashley Coleman as well.
I think that's right. Not entirely sure. That's so.
Here.
All right, Mr. Davis Lewis, I don't know why Mr. Paycheck's not here. We've provided him with the opportunity to appear by Zoom. He's been given a Zoom invitation. He's not responded. I don't know where he is. I can't do anything without your attorney here, so. I'm gonna reset you to February 13th. 2024.
Here.
I got you, Ms. Coleman. At 12:45 PM on defendant's motion. I would suggest you call Mr. Paycheck. He's on here. Mr. Paycheck, Mr. Hayes Lewis, you're sitting at the table waiting for you.
Judge, I thought we entered and waived on this. This is my initial appearance for this gentleman.
So we just saw this judge throw that guy in jail for having one drink on Christmas. I don't know what would have happened to this attorney if he wouldn't have shown up when he's there for all these people. Almost all these people have him. So yeah, I was terrified for this man, and he just strolls in at the last minute, and you know he didn't do a great job. I think he just was running really late, so he wasn't put together. So you know he sort of stumbled around for a bit, but he made it. There's a happy ending to this story for all these poor people. I think that judge would have got him. I'm so glad he showed up. Okay, so I don't know how many of you remember, but we had a SovSit case a couple streams ago, maybe a month ago, I think, and these people are about to get evicted, and they didn't want their own attorney. They were spouting off these weird rules and everything. Well, I have an update on that case right here.
10, that's 232-01-20908. I see your client online, Mr. Glissette. Right. And then do we have Rebecca and Craig Bareilles? I believe they're in iPad booth 1, if I'm not mistaken.
Yes, right here, Your Honor.
Okay. And you are Rebecca Bareilles and Craig Bareilles?
That is correct. Yeah.
Okay. Let me just get into that digital file quickly here, folks.
Yep, that's Cammie, the prosecutor. Now she's a magistrate today.
Okay. In this one, I did grant a 2-week continuance on December 22nd. The court signed an order of formally appointing Mr. Kiernan on December 28th. How are we wanting to proceed today on this case?
Well, what I can tell the court is I received yesterday late the answer and a motion to dismiss and a motion to stay proceedings. Our position is that both motions aren't timely for today. We had a 2-week continuance when we were here on the 22nd. Our understanding was if, based off this court date that was set today, any motion should have been filed by last Friday. Although I understand that the court didn't sign the order appointing, we certainly did have knowledge, and I believe, if I remember correctly, the attendance in this matter had already been screened at the previous hearing. So when obviously I haven't had a chance to respond to the motions. They're not timely for today to be able to respond. So I guess if the court's going to consider those, we need an opportunity to respond. We don't think that they are dispositive to the case. So I guess we'd like to have a writ issue today based off the 3-day and the criminal activity. If the court's going to consider the motion to stay and the motion to dismiss, I'm assuming the court is going to need briefing from me on that to be able to make a ruling. I have some oral argument, but I also don't want to put my clients in a bad position if the court needs briefing to make a decision. And again, they're not timely for today.
Right. Mr. Brunetti, any position?
Yes, Your Honor. On the issue of timeliness, I understand the civil rules require certain timeframes on motions, but unlawful detainer proceedings are governed by the RLTA, RCW 59-380. First sentence of it says that any defenses can be presented orally or in writing at the time of the hearing. That all being said, so it's not untimely. That all being said, though, in these situations where we can't get things, we can only get things filed either the day before or shortly before the hearing, we would have no issue with the court granting a continuance to give counsel an opportunity to respond. But I do believe on the issue of timeliness, I think the court does need to consider it one way or the other, whether it's either today or giving counsel an opportunity to respond.
And I guess my only commentary would be that, yes, defenses, but these are actual motions. And again, 2 weeks ago, the court, we didn't want a 2-week continuance. 2 weeks ago, we wanted a 1 week because we were concerned about the criminal activity and the fact that what's happening in the court strongly cautioned tenants at that point because of the concerns. We're here 2 weeks later, and literally at like 4:30 yesterday, I saw motions and a response. So I guess my position is we're just frustrated by the fact that they got the 2-week continuance, so they would be able to, in my opinion, timely respond. And then the day before the hearing at 4 o'clock, my office is fax served 2 motions.
Yeah, here's what I'm inclined to do because, and to be honest, I was in court all day yesterday, so I didn't even see this motion until this morning. I have read through it, but I would agree it is the type of motion and response that Ms. Tideman would be entitled to respond to. So, I mean, I will consider it, but I do believe Ms. Tideman should be able to respond. I understand that we've already had a 2-week continuance. I would be inclined to set this over just 1 week unless the parties think they need 2 weeks. I guess Ms. Tideman, since it's your schedule and your response and your, review time, I'll give you first right of refusal over the 19th or the 12th.
I don't need 2 weeks. I need 1 week. We want to move this forward, so we want to do it as quickly as possible.
Okay. So let's set the Glissette-Bareilles matter over just 1 week to January 12th at 9 a.m.
Is that Friday, Your Honor?
Yeah. That is next Friday. Oh, go ahead, sir. Yep.
Sorry, I didn't mean to interrupt. I actually have a court date on that day at the same time.
Is it here?
It's on the 9th. I'm sorry. It's on the 9th?
It's on the 9th.
Oh, I'm sorry. It's on the 9th.
So you're good? Okay.
I'm good. Sorry, Your Honor.
Okay. If something comes up with a scheduling conflict, just reach out to your attorney, Mr. Kiernan, okay?
Yes, ma'am. Thank you, Your Honor. I appreciate you.
Okay. Yep. We'll see you back on the 12th.
Alrighty. Hey, you have a great day.
You too.
Thank you. Thank you, guys. All right.
Okay, so yes, the commissioner for this is Carney or Carmi, I can't remember, but she's the prosecutor in a couple of the other court cases that we have on here. She does both. Kiernan is his defender, but Bernetti's stepping in today because Kiernan got really sick. Now, I don't think these people should be in that apartment at all. They should have been kicked out a couple months ago because there's a lot of criminal activity there. He's going to court for that separately. And the first time they were here, they caused ruckus. They were arguing and sob-sit stuff all over the place for an eviction. They didn't want an attorney. So I think they should be kicked out. However, I really love Kiernan. He does a really good job. I remember once, he dared the prosecutor to do what the prosecutor said she was going to do. And I didn't know what it was because it was all numbers. She's like, well, I'm going to file an FC04. And he replied well, go ahead, do it. I will just file an FC5. And the prosecutor just shut up right away. It was awesome. He's amazing sometimes when he's on point. But he wasn't here today because he was sick, which is why the motions were not as timely as they wanted them to be. But we're going to see what happens with these two. We'll see if we can catch them again because they are a couple. They didn't do anything today, unfortunately, but yeah. Maybe next time. We got to see Cammie again. Where are we going? Oh, let's see her. Okay, we're going to see Kiernan in this next one. And his clients don't like him at all.
The docket 232-010-7308. Michael and Suzanne Long, represented by Ms. Sturm. I assume Ms. Tideman is covering for that today. And then Mr. Kiernan on behalf of, I believe, Shyla Barnes only.
I guess I see Mrs. Barnes and Mr. Pryor on. I would ask, it's unclear if I am continuing to represent them.
Oh, okay. So are you Shyla Barnes?
Yes.
Okay. And is Love Pryor with you as well?
I'm here.
Okay. What can you tell me about your status as being represented by Mr. Kiernan, or what would you like the court to know?
Are you speaking with me or Ms. Barnes?
Well, let's start with Ms. Barnes.
I don't know. I wasn't involved in the conversation yesterday that they had.
Okay.
I've been severely sick, so I haven't been able to do much of anything.
Okay. Okay, sir, what would you like me to know?
I was just saying that what I spoke to Mr. Kiernan yesterday is that I was feeling like he wasn't being an advocate to help us. He was being an advocate to my landlord, which nobody has spoke to other than like 2 people. And I have money set up. I've given her money, and then she's saying that we haven't given her any money. I have receipts. I have invoices. I have repair work that I had to pay for myself. And yet still I'm winding up looking stupid because like in my lease, it states that we're supposed to have maintenance and this and that. And every time I call or text or try to contact her, there's nothing.
Okay. Mr. Kiernan, any input from you?
Well, my understanding is they want to, I guess I don't really know how to proceed here either.
Okay.
Quite frankly, I know that they indicated that they want to get on a 410-3 repayment plan. Perhaps I don't know if they want to advocate for that for themselves, and I can.
I have no problem with the payment plan, none whatsoever. I just would like my landlord to actually say that she's not doing anything here.
Okay. So let's resolve, I guess, representation issues so I know who I'm talking to today. So Ms. Barnes, are you, so previously on December, I think 14th, there was a notice of appearance filed. Oh, sorry, I apologize. December 15th that appointed Ms. Barnes to Northwest Justice Project via Mr. Kiernan. Are you asking to be continued to be represented by Mr. Kiernan, or are you representing yourself?
Representation would be nice. I don't know the legalities that I would need to know to make informed decisions.
Okay. And then is it Mr. Pryor?
Yes, ma'am.
I don't have a specific notice of appearance on your behalf. Are you?
Both of us was on that notice of appearance, ma'am. Both of our names were on that notice of appearance.
Well, would you like me, to represent you in this matter?
Jeff, I have no problem with you representing me. Don't get me wrong. I said that. I just felt like I was a little upset because nothing that I was doing was getting even represented. Like I've given this woman money. I've made phone calls.
So hold on.
I'm just trying to figure it out.
And I'll just say this, in my experience, I think sometimes when tenants come to court and say things like, I don't think the attorney's representing me, it can sometimes be more of an issue of, yes, attorneys have a duty to zealously advocate for you, but it's also their duty to explain the strengths and weaknesses of your case. And I know sometimes it can be hard to hear what the weaknesses may be. So if you are asking to be represented by Mr. Kiernan's office, that's great. I would just ask that you keep an open mind and realize that his agency does this day in, day out, and is trying their best to give you both the strengths and weaknesses of your case, okay?
Yes, ma'am.
Okay. So Mr. Kiernan, I guess given that it sounds like Mr. Pryor does wish to be represented, my notice of appearance and the order appointing is just for Ms. Barnes. What are you asking to do?
He signed a retainer in our office, so he should be on there.
Oh, he did sign a retainer? Okay.
So I guess we would ask that the court stay this for 90 days under a 410-3 repayment plan. Defendants are able to make a immediate payment of $1,700. They will then be able to make a payment of $1,933 on January 15th, and will continue to make that payment for 3 months until they're able to make up the rent. They are both working and they can testify to that. They have the money to be able to make these payments. They're both kind of, working pretty hard to make those payments. And like I said, they're both available here to testify if you'd like to go through that. As far as, understanding the circumstances, they can testify that, they lost some jobs in the move previously. So they had some difficulty making the rent as far as the first prong. As far as the third prong, when it was intentional, it obviously wasn't. They were trying to make payments. There were some disputes with repairs that were made where they felt that they made repairs or the landlord was not making the proper repairs. So they feel like they should be credited for those. I would also look at the tenant's payment history. This is a relatively short rental, so there really isn't too much there. Whether they were in substantial compliance with the rental agreement, I would just like to state there's no other indications that they haven't been, good tenants. There's no 10-day notices or anything like that. And I just ask you to look at hardship on the tenant if evicted. These two clients have several children that they are the sole custodies of. They need a chance to maintain housing for them and their children. There's really no other options if they're homeless. And again, I know we didn't get a declaration on these, so my clients are ready to testify. And I think they would like the chance to do that.
And Ms. Tideman, I know that you are covering this for Ms. Sturm. What position do you take on, I guess, a couple things. One is, since there is this oral request for the repayment plan, are you requesting any additional time, or do you want to move forward on that today?
I think the concern is just that this has already been set over for a month because there was a bunch of issues. I think Ms. Barnes at previous hearings has said the same thing she said today, which is I've been ill and not been able to do anything. We didn't receive any
false.
or
We got the paperwork.
I have muted Ms. Barnes and Mr. Pryor. This is Ms. Tideman's turn to speak. I will come back to you and your attorney. Please be patient. Go ahead, Ms. Tideman.
Thank you. They owed $4,500. They haven't paid rent since August. And obviously we have 2 more months now where there's been no rent. So that's an additional $3,000. We're talking about $7,500. We're behind. We didn't get any indication. And honestly, I'm going to be frank with the court that the presentation I see today doesn't lead me to believe that we're going to see any money out of them. It appears that we have people saying a lot of information about how they shouldn't have to pay and how that they're angry about certain things. These aren't people that appear to be willing and ready to make payments despite Mr. Kiernan's representations. The comments I've heard from the tenants today have been very much geared for we shouldn't have to do this. We're mad at our landlord, and here's all the reasons that we shouldn't have to pay. But I mean, we're talking about $7,500 that they're behind. They've not paid anything into the court registry. If they're working and have the ability to make payments to go forward with the payment plan, then what they should have done is gotten some money together and put it in the court registry to make some kind of good faith effort to show the court that they're willing to do that. But given the history, the continuances, sort of their the case has been going on from our client's perspective, a long time to wait for us to get to this point and then not to have any sort of filing in writing ahead of time and then have them come here today and complain largely about the landlord, largely about the fact that they don't believe they should have to pay money, not have paid anything into the court registry despite having representation, despite knowing what their obligations should be. I don't believe they're going to fulfill a payment plan. We're here on a non-payment of rent. They haven't made any efforts. They haven't paid anything to court registry. And by statute, we should receive the writ today, despite what's being presented here, because it just simply, I can tell the court, I think if the court issues a payment plan, I think we're here very quickly back with the same request to get a writ, because I don't think our client gets one dime.
Mr. Kiernan, go ahead.
I would just ask that you give the defendants a chance to kind of explain that they can make the payments. They strongly feel that they are able to, and I ask that you identify them. and give them chances. We were not able to get a declaration in. Like I said, they are both working. They both strongly feel like they can make this payment plan. And I would also actually note, they are both, having a family that they're trying to maintain a roof over in this winter. They are really trying to make these payments, and they believe that they can make these payments. And I would ask that you question them, and we can kind of figure that out so we can get some more information, Your Honor.
Ms. Tideman, go ahead.
I was just going to say, if the court's considering a payment plan, then probably what I'd ask is it gets it over 1 week and we see payment into the court registry of a substantial payment to actually show that they're going to make any kind of good faith attempt. And if we come here next Friday and there's been nothing paid, then that might be the balance for the court. But I would suggest that if the court's considering a payment plan, we need to see some sort of good faith. What I don't want to do is have them go on a payment plan. We have to wait 30 days essentially to come back to prove that they haven't done it. I'd like them to make a good faith effort. If they can make a payment today and that's what's being represented, then let's have them make that payment. Let's see what they can pay to the court registry. Let's have them make a substantial payment toward back rent. And then maybe that informs our decisions going forward.
So Ms. Barnes, Mr. Pryor, I'm going to go ahead and have you unmute now. I've just sent the request for there. Can you hear the court?
Yes, ma'am.
Okay. Are you guys able to turn your camera on?
1 second. Gotta figure this out.
Okay.
She can. I don't know where it's gonna stand at. I don't know where the view's gonna be at.
It's not letting us turn the camera on.
Okay. So which one?
Unable to access.
Okay. Which one of you primarily is able to, under penalty of perjury, talk to the court about payment ability?
I guess that would be me. I'm not sure what that means.
So which one of you is able to answer questions about when and how much money you can pay?
We both can. So I'm not sure.
I'm not asking you to do it yet. I'm asking you to identify first who's going to make those statements to the court.
Oh, I am Shyla Barnes.
Okay. Ma'am, I'm going to have you go ahead and raise your right hand, and please tell me when you're doing so, since it appears you're not able to turn your camera on. Are you raising your right hand?
Yes, ma'am.
Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay. You can go ahead and put your hand down. Can you identify yourself for the record? Give the court your name.
I am Shyla Barnes.
Okay. So through your attorney here today, you are asking for the court in its equitable powers to grant you a repayment plan rather than an immediate eviction occurring. Is that correct?
Yes.
Okay. You've heard the attorneys arguing, and there does appear to be well over $7,000 in back rent that is owed.
Mm-hmm.
Do you understand that?
Yes, ma'am.
Okay. As far as an initial payment towards any sort of repayment plan, how much are you able to pay to the landlord? And
I'm sorry, it cut out. I'm not sure what you just said.
As far as an initial payment towards this back rent, how much are you able to pay and when?
$1,700 by tomorrow.
We could do $1,700 by tomorrow. Like we could have that put in there by tomorrow. Oh, tomorrow's Saturday. As soon as we can, we'll try and get it in there today. Like I said, I've been highly sick, and so I haven't been able to do much. We will try and get it in there today. If we can't get it in there today, then as soon as the court is open again, we can make sure that it's in there. And then I get paid again in January. I don't have my calendar in front of me. It should be like the first week or the second week where I can make another payment. And then it's like, if I can put money in every 2 weeks on my side.
So if I am to grant a repayment plan, it is going to include paying towards the retroactive rent that's due, but staying current on, I believe, the $1,500 a month. You think,
Yes.
will you be able to do that?
Yes. And whatever amount is left over, I think it's, and that's fine. Yeah, I can do that. That's fine. Sorry.
And can you tell me why you believe you will be able to do that? What is your monthly income?
I get anywhere between, just me personally, I get anywhere between $2,000 to $2,500. It kind of depends. And sometimes more. That's just the minimum. I get anywhere from that amount upwards with my new job.
Okay, I'm going to hear from Mr. Pryor. Mr. Pryor, can you raise your right hand and tell me when you're doing so?
I'm doing so.
Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. Go ahead and state your full name for the record.
Love Pryor.
Okay. And what is your monthly income?
My monthly income is $29.70.
Okay. And Ms. Barnes previously testified that you all would be able to make a $1,700 payment into the court registry today or the next date we're open, which is Tuesday, December 26th. Is that accurate?
That is accurate, ma'am.
Okay. And if the courts were to grant a repayment plan, would you be able to make the, I think the proposal for your attorney is about $1,933 a month while also staying current on your rent?
Yes, ma'am.
Okay. Ms. Tiedemann, I think what I'm inclined to do is proposal. I'm going to order that I'm going to set this over to next Friday if the parties want to submit additional materials on whether or not I'm granting a full repayment plan. But I'm going to order even just to get to that threshold level, given I think a lack of documentation I have in front of me today, but making a baseline showing that these parties have gone on record stating they think they can afford it. I am going to require that $1,700 per their testimony be posted in the court registry today or by end of day, December 26th. And then we'll come back on Friday and make a ruling on the payment plan. Obviously, if I rule against it, that money will be returned to them. If I grant it, it will be credited towards that initial down payment of the repayment plan.
That works for me, Your Honor.
Does that work for you? I think that strikes a balance here where I don't really have declarations to make a full finding on the repayment plan today. And it takes into account kind of the length that this case has been pending for some time. So I don't want to just shift everything over to next Friday. Okay.
Yes, ma'am.
Okay. So thank you for your time here. So Ms. Barnes, Mr. Pryor, go ahead and make that $1,700 payment into the court registry. If that payment is made, then we'll move forward to argument on the full payment plan on Friday.
Yes, ma'am.
Okay.
All right. And I'll give you guys a call here very shortly so we can talk about next steps.
Okay.
All right.
All right. Thank you all for your time. We'll see you next Friday. I think that ends docket unless I'm missing anything.
I think it does. Have a good holiday, Your Honor.
Okay, you too. Take care.
Next step is pay your bill. Go pay your bill, or you're not going to have a place to live. All right. This next one, it's a train wreck until the end. And then saving grace. It's good. I never ever see cases like this next one, so it's nice. It's a nice change.
Your driver's license.
And the carrying a weapon without a valid license for Mr. Willis has been not processed.
Yes, Your Honor, that's right. We received an issue of the concealed weapons charge.
All right, so the only charges going forward are the discharge of firearm, and reckless conduct?
Yes, Your Honor.
Okay. Is that what you need to verify, Ms. Bolton?
Yes.
Okay. Good afternoon, Mr. Willis.
Afternoon.
Can you raise your right hand for me? Do you swear affirm your testimony you're about to give before this court for the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. All right.
Yes, Your Honor.
Yes.
The defense stipulate to a factual basis, venue, and ID.
We do.
The state's recommendation, Your Honor, for the discharge of a firearm on or near public highway or street. And for the reckless conduct, it's gonna be a 12 months probation, and it's gonna run concurrent with the reckless, served 10 days. The defendant did not serve any days in custody, so there's no credit for time served, Your Honor. Balance probated, 80 hours community service, forfeit of firearm, gun safety class, stay away from 1890 Myrtle Drive, Southwest Atlanta, Georgia, and get the GED, which he already did, Your Honor. That's all.
Would you give me the statute basics, please?
Yes, Your Honor. One moment. On or about, the state expects the evidence to show that on or about April 7th, 2020, the defendant did, without legal justification, discharge a gun or pistol within 50 yards of a public highway or street, Your Honor, in violation of OCGA 1611-103. That's what I have, Your Honor. Did you need more facts?
You were doing it because you were stuck, right?
He endangered the bodily safety of the general public by consciously disregarding any substantial and unjustifiable risk that his act by firing a weapon in a residential area, Your Honor, there are people around there, people are living there, that would cause harm or endanger the safety of such persons. And the disregard constitutes a gross deviation from the standard of care, which a reasonable person would exercise in violation of OCGA 16-5-60B.
Are you gonna have anything further for me, counsel, in regards to that?
Yeah, I do, Your Honor. Back in 2000, this was in 2020, my client was 22 years old. And he had been, this weapon was not stolen. He doesn't have the weapon anymore. He forfeited it when he was arrested. However, what happened was that the gun had been given to him by a friend. Don't know how friends, they're not friends anymore. And he said it was stuck and he was messing with it to try and, I don't know anything about guns. I'm from England. So if anything, I don't even bring them up at trial because I sound stupid. But basically, from what I understood, the weapon was stuck and he was trying to unstick it and it went off.
Right.
It was not pointed at anyone. And hence, there was no aggravated assault charges in this matter. He hasn't been in any trouble since. He does not have a gun. He has taken a gun safety course since then. So I would just ask the court to accept this negotiated plea. He is 26 years old now. He's gainfully employed. And he does have his GED. He accepts responsibility for this. He's been coming to court and made this decision today, even though he will be going into custody. We are going to ask the court for a turn-in date within whatever parameters the court would allow us to do that so that he could let his employer know where he's going to be.
What is his history?
Yes, and Your Honor, if I could add one thing before the history, the suspect also admitted to firing 2 rounds in the back of the complex. his history.
It was stuck twice.
He had a 10-year probation sentence for theft by robbery by snatching. When he was very, very young. He got off probation for that in 2016, I believe, correct?
So cycle 1, petty theft, first degree. That's all I have on this one.
Okay, where's he working?
I got assigned to warehouse in local road. So I was out of state working on lawn care. But when the winter hit, they started laying people off. So I moved back.
Okay. Didn't you say you got another job for the winter?
Yeah, I bought a pressure washer, so I just do the pressure washing on the side.
Your Honor, in additional criminal history, there are 4 cycles. Cycle 1 was criminal trespass, which was null crossed. Cycle 2 was robbery, which was a felony. That he used his first offender act. Was driving without a valid license. Time expired, hit and run, time expired, and cycle 4 probation violation, Your Honor.
Okay. When does he plan on doing the time continuous?
Yes.
Okay, and he understands that he'll get 2 for 1, so that the 10 days will be in essence 5.
Yes, I did explain that to him.
Okay.
Of course, it's up to the sheriff.
Right.
You know, hopefully it'll all work out. Yeah.
Okay. Anything else, counsel?
Well, I don't want to push my luck, but I was going to ask if the court would consider waiving his probation fees. He's fairly indigent right now since it's quite cold and no one wants their houses washed and they're all poor after Christmas. So I was going to ask the court for that and then push my luck even further and ask for early termination.
The state would object, Your Honor.
Okay. I'm not going to terminate him early, but I am going to waive some probation fees for him to help him get on his feet. All right, anything else before I take the plea?
No, thank you, Your Honor.
Okay. Mr. Willis, it's my understanding that in case 20CZOV000042, you wish to plead guilty to discharge a firearm at or near a public highway or street in reckless conduct. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Does he have a place to stay? Do we know? Do you have a place to stay?
Yes, he has 2 addresses. It's got one down in McDonough and one in Buckhead with family members.
Let's see. And when does he want to turn himself in?
We hadn't really gotten that far.
I guess next week.
Okay, so today is Wednesday.
Wednesday the 3rd.
You want Monday?
Yeah, Monday's fine.
Did I give you time?
Yes, Your Honor.
Yes, Your Honor.
Okay, so what time can you get there by?
Well, I wake up early.
Say it again?
I wake up early.
Okay, so you want to go first thing?
Yeah.
Okay.
Yes, sir.
All right. So 10 o'clock?
That would be after traffic. Yeah.
Okay.
Okay, so, you'll turn yourself in by 10 o'clock, and what is next Monday? Today's the 3rd? The 8th, Monday, the 8th, and does he know where to go?
Right street.
We'll make sure you know where to go. I'm gonna waive 6 months of the probation fees, okay? That should give you enough time to get yourself a job and to have some time on the job, so that get on your feet before you have to start paying the probation fees. That will require that you be on probation the whole 12 months. But I'll help you out with the first 6 months of probation. Anything else, counsel?
No.
Okay.
You have any questions?
I
Can't answer.
was going to explain like why it's happening. But
Well, that would be a trial issue.
oh,
Mhm.
I was just gonna say like, I wasn't just running around shooting. After it happened, I talked to the officer and explained to him I had like a bullet like large. Then it wouldn't cycle back. It wouldn't rack back. Say if I went to eject around, it wouldn't rack back. And so I thought at the time it would just go into a little area where nobody was around in the grass. And I fired the round out, and then I told the officer that. He was like, no, instead of doing, he showed me like the proper way to do that if that ever happens. It was like, yeah. But
Okay. I'm hesitating because, you're a young man, you worked out a deal, but, I don't want to see you incarcerated. I want to see you get on the right foot so that, you can be productive. I just don't know how to, what would be of, you could have really harmed somebody on one hand. But I don't know, to be quite honest, if you spending time in jail is the solution to it. What you're telling me, I don't know if that punishment fits the crime. That's the way I personally feel about it. I think you could be better served by being productive within the community as opposed to just sitting in jail. So I guess what I'm saying to you is that I'm not going to accept the recommendation. What I'm going to do is give you more community service in lieu of jail. So you won't be incarcerated, but you'll be helping the community by being productive. Okay?
Sure.
So and was he arrested on citation? Well, what was the issue? Was if he didn't spend any time in jail,
When did the officer give you the gun, but take your gun? What happened?
well, I was detained by the security.
The guy that called the cops.
And then the police came and ran the gun, and it came back clean because it was legally purchased.
And then they sent you home and you got a notice in the mail to come to court?
No, I think it was around COVID when COVID was happening. So I think the officer called up there and
they wouldn't take
you. They said, no, just give them a citation. It's too much going on.
Gotcha. Thank you. Yes, that would be April 2020. So that's when COVID really was exploding.
All right, I'm not gonna have him serve any jail time. I am going to increase the hours of community service from 80 hours to 180 hours of community service. I think that you'd be better served by being out in the community and doing something productive. Okay, I'm giving you that opportunity. With all the other conditions that you agreed to, I still will waive those fees for you for the first 6 months.
All right.
I hope you use this opportunity to do something positive and get on the right foot, okay?
Yes, sir.
All right. Anything further, counsel?
No, thank you, Your Honor. We appreciate your candor and flexibility.
Okay. Good luck to you, Mr. Willis. We're gonna give you where you need to report to probation, and I ask that you report within the next 2 weeks or so.
Yes, sir.
Okay?
Right.
All right, good luck to you. Have a seat.
Just like a Hallmark movie. Such a good ending. He ain't going to jail, guys. He ain't going to jail. That was so sweet. I had to put it in here. That was so sweet. I mean, the guy went off twice, so we know he was lying, but, he's not going to jail anyway. If he was in front of that other judge, though, he'd be serving life. Okay. I'm hesitating on the next one because I don't want to start. I mean, I love stirring the pot, so maybe I have it here to stir the pot, but I don't want to. So can we just all, for the next 20 minutes, be nice to each other? Yes, this has something to do with the Republican Party in the fact that it's the way the way the laws work within with how the party runs. Same way Democrat, they would have the same laws. It has absolutely nothing to do with politics. But it's really interesting because I didn't know this about how, there's just some of the things that I didn't know about how election workers are appointed or election officials are appointed and things like that. It has absolutely nothing to do with nothing. It's basically just law. It's an interesting case about law. Yeah, it happens to be the Republican Party, but pretend it's a business. And just don't. We don't have to. It doesn't go there, so we don't have to go there. Yeah, I'm from Pennsylvania, James. Let's go. I'm going to do this. I didn't know if I should, but I'm going to do this. And I think that we can all just be nice.
Good morning. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the courtroom and also online. And we're here in the matter of Britsky and McKinless via Maine, file 23-9009-AW. Counsel, you want to state your appearances, please?
Thank you, Jeremiah Buffalo Wergo, P77997, on behalf of Anne-Marie Maine, who is seated to my right.
All right, and Mr. Britsky and Mr. McKinless, good morning, and you're representing yourselves in this matter, is that correct?
Yes, Your Honor.
All right, so we had our first hearing over in Sheboygan County, and I granted the defense motion to change venue over here. Allowed the plaintiffs time to amend their complaints. It looks like, looking at the file, it looks like they did. Dismissed the third plaintiff from the action and set it for today to consider the question of preliminary injunctive relief. So I guess, Mr. Britsky, what's your position today with regard to whether the court should grant preliminary injunctive relief?
Good morning, Your Honor. You dispensed some wise advice toward the end of the trial in Sheboygan last Wednesday. And the biggest advice I think you said, get together with the attorney, sit down and get this resolved. And so on Friday morning, I reached out to Jeremiah Wergo. We had a frank conversation and he knocked my socks off with a revelation he made. Because if you recall in our complaint that you read Wednesday, one of the first things in there is Scott Ogney said that the county clerk was guilty of negligence and malfeasance inasmuch as she didn't notify Chairman Britsky that we're supposed to have those nominees in 10 days. And I believe that. I went into that courtroom thinking that. Friday, I talked to Jeremiah. He said, Bob, check your email chain. Because on October 9th at 4:22 in the afternoon, the county clerk emailed you and informed you of the 10-day rule. Really? I opened my email, went back, there it was, sure enough. However, the way she notified me was kind of in veiled terms, because I want to read you the exact quote of the county clerk's email informing me about the 10-day rule. She said this, quote, the turnaround time is also stated in the manual as due 10 days from notification. I'm not the sharpest crayon in the box. I didn't realize that what she was trying to tell me is that, Bob, you got 10 days to get the list of nominees to me so that I can act according to law and appoint from that list of 3 nominees. Honestly, it went right over my head. Now, sitting here this morning, it's perfectly clear what she meant, and I was wrong in not getting that list to her, but frankly, I didn't understand the way that she wrote that. So anyway, I was surprised to find that out. We spoke, Jeremiah and I spoke, and he said, why don't we meet Monday at 10:30 here in the courthouse down in the old room where they used to have the Board of Commissioners meeting. And I got a hold of Jim McKindle's, and sure enough, Monday morning, 10:30, we all were there. We made a brief introduction, and at that point, Jeremiah Wergel brought out this resolution. He said he would give you a copy. Do you have a copy for the judge?
If I may approach, Your Honor?
Yes.
Yes, Your Honor.
It was a wonderful piece of work for the most part. It's entitled Stipulated Order Dismissing the Case. And I'm confident that shortly it will be dismissed. But he gives us the opportunity to sign off on this. And if we sign off on this resolution and you sign off, it's all over. At this meeting on Monday, Jeremiah Wergel gave Jim and I one copy, and we put it between us and we read through the entire resolution. Most of it is perfect. It's excellent. It resolves the problem. The first thing, however, if you look at it, number 1, it says, it is hereby ordered that defendant Anne-Marie Main, Presque Isle County Clerk, committed no error and acted with an authority without malice. Your Honor, that simply is not true. And we're going to find that out in just a bit. Okay. But first of all, I must admit my error led to more errors on her part. And we can talk about that a little later. But anyway, Jeremiah said, don't sign now. Take these resolutions home, sit on them, show up Thursday morning on the 21st at 9 o'clock, and we'll see where we are. Jim McKinnell and I discussed this. At first, he said, I can't sign it. Me, I was kind of on the fence. The more I look at it and thought about it and how this all played out, I said, I can't sign it either. So we have a resolution. And if you're willing to strike item number 1, we got an agreement right now. If not, we'll talk about it, and I will show you why number 1 is false on the face.
Mr. McKinless, do you share Mr. Britsky's position?
Yes. Not 100%, but yes.
You want to tell me?
Once Bob elaborates, then I can find out more what he's thinking.
Okay. Mr. Wergel?
Your Honor, I wasn't served with a copy of any amended complaints or anything that was filed in the last week.
Yeah, I didn't get a judge's copy either. I just see that it's filed here. No, is that the? Oh no, it's that. Oh no. Well, it's stamped December 19th. Well, this might be just the same complaint. I just didn't. Okay.
Your Honor, we got a note from Karen Brewster indicating that we may amend the complaint.
Right.
We may, but we didn't have
You
to
didn't.
because I felt we're so close to resolving this.
Gotcha.
We just got one little item to deal with and it's
Okay, that's
resolved.
fine. That's fine. So there's no amended complaint that was wrong.
If I may, Your Honor, just a point of clarification. I have the old case number on this proposal. I just want to make sure that to note that there's a new case number.
Oh, yeah, I see. Okay.
My apologies.
Case number in Presqu'île is 23-33418. Gotcha. All right, well, Mr. Warhill, your position as to what you just heard?
There's nothing that Mr. Britsky has said that is untruthful. We spoke, we met. Unfortunately, we won't be able to resolve without agreements to the first paragraph of the proposed resolution.
Well, let me ask you this. I mean, give me a second. I've been trying to scan it, but everybody's been talking. So give me just a solid 60 seconds here to make sure I've got this. Paragraphs 2 through 6 certainly do solve the dispute between the parties in that defendant has made an appointment filling a vacancy under the statute, and the defendants, particularly Mr. Britsky, as the chair of the county committee of the Republican Party, objects to that appointment. This sort of would reset that clock and allow that statutory process to go forward. Paragraph 1 is the sticking point, saying that it's hereby ordered that defendant Anne Marie Main, Prescott County Clerk, committed no error and acted within authority without malice. Maybe I can share just on my review some preliminary thoughts about this that may help the parties. Both trying to, I think there's something that you could both say and agree on that would resolve it. Here's the thing, the statutes, MCL 168.24D, does say that the county clerk that has the responsibility to fill the vacancy. So that's her duty under the law. Subsection 2 of that statute says that the county committee shall, within 10 days, shall nominate 3 interested persons for the position and submit the list of nominees to the county clerk. The problem here began when the defendant, actually the county committee is not here as a defendant, but Mr. Britsky, you're the chair. So I'm just speaking that you're the county chair, you're the chair of the county committee. The case started when you, Mr. Britsky, violated this statute by not submitting the names within the 10 days. That's correct. That started the problem.
Yep.
I do think that as I read the statute, Ms. Main is now in a difficult position. And my reading of that, subsection 3 says the county clerk within 10 days from the receipt of the list of nominees shall appoint one of the nominees. So she's in an impossible spot. I do not believe that she acted in any bad faith at all. She appointed somebody that, to her knowledge, was a member of your local committee. And I'm not sure of this, but from the pleadings that I saw, may even have served on that county committee in the past. So she's trying to make the best of a bad situation. I don't, however, necessarily agree that that was within the sentence within her authority, because the statute says she's got to pick from the 3 names given. It doesn't authorize the clerk to appoint somebody outside of that universe. The clerk would have had a legal remedy in filing an action for writ of mandamus, I guess, or some kind of action against the local Republican Party and says, hey, the statute requires they give me names, they're not doing it, judge, order them to do it. And I clearly would have granted that kind of relief. I agree wholeheartedly that based on my review of the pleadings, that the defendant, Ms. Main, the Prescott County Clerk, did not act with any malice, and I think she acted in good faith to try to solve a problem that you created. I don't know that I would feel super comfortable signing an order signed by the court that adjudicates that she acted within her authority, because I'm not sure that's clear in the statute. So why don't we take a break and you guys talk a little bit and see if there could be some language, Mr. Burgo, that just talked about good faith, bad faith, malice, stuff like that, but omitted parts about legal authority. I don't want to go too far and suggest exactly what a settlement language ought to read, but maybe that gets at what you both are trying to say. That Mr. Britsky, it seems, is not wanting to concede that this was a proper action, but Ms. Main wants an order to be clear that she was not trying to play any games or shenanigans or act in bad faith. I think you both could agree on language that would accomplish both of what you want. So why don't I step off the bench and let you talk a little bit more. Main file 23-3341 AW. And Mr. Wergo, did you and plaintiffs have a chance to speak and see where we're at?
Yes, Your Honor, and I do believe we have a resolution. If I may approach?
Yes.
Your Honor, what I'm presenting to the court is a marked up version of the proposed order dismissing that was originally submitted. Paragraph 1 has been altered to strike the language committed no error and within her authority, and in place, replace it with acted in good faith. So number 1 would now read, it is hereby ordered that defendant Anne Marie Main, Presque Isle County Clerk, acted in good faith and without malice.
And regardless of what would have happened at a hearing today, based on my preliminary review, I would almost 100% have made that as a factual and legal finding today at the outcome of anything. All right. And then it further contains paragraphs 2 through 6 that will kind of reset the clock and give the plaintiffs 10 days to submit the names. And then upon receipt of those, the defendant would rescind the appointment and then would appoint from the list of candidates that this is a binding order and that this would dismiss this matter with prejudice. Mr. Britsky, do you agree to those terms?
We agree with what Jeremiah just told you.
Okay, Mr. McKinless, do you agree with that as well?
Reluctantly, yes.
Okay. Well, I think what we'll do then is I'll give this to the bailiff and see if you all are in agreement. Then have you execute that and then present it back to me for signature.
I'm to do what with this, sir?
Sign it.
Sign it.
Yeah.
Oh, on the back? Okay, second.
It's got a signature block.
Okay, thank you.
'21st.
I put the date here.
Yeah.
Don't worry, he's not done yet. This guy in the striped shirt signing right now. He has more to say.
You got one date, and then just sign your name, Jim.
That's yours? Okay. I didn't want to steal your pen. I have extras.
I think he really dislikes this clerk for some reason.
They're both involved because it's another trial over this. And so
All right. Well, reviewing the terms of the fully executed stipulated order dismissing the case, I believe that it is a very good resolution of this outcome, and I commend you all for sitting down and talking about this. You know, our laws and our election codes require the cooperation of all sorts of officials and all sorts of folks. And so you sitting down and talking about this this is a win today because it shows that reason and good judgment have prevailed today. So I'll
Your Honor, may I ask a question?
Yes, sir.
I submitted to our county clerk minutes ago the 3 names of nominees, which I should have done back in October. It's done now. My question is simply this: does she now have 10 days to select from that list who she appoints?
That's beyond the scope of what's in front of me today. And in case anything goes sideways on this, I can't pre-opine about anything.
I think the law says that. If I had gotten that list in on time, she had 10 days to pick from that, didn't you, Anne Marie?
All right,
You had 10 days from that.
Mr. Britsky, hold on a second, sir. Hold on a second. All I can do today is resolve a case in front of me.
Yeah.
You're wanting to talk about future actions and hypotheticals. A courtroom is not the place, the proper place to talk about that, because if something were to go wrong, then people can come into court and have recourse of law. We can't have judges guessing about what might happen and what I would do if X and such happen.
Okay, thank you.
Thank you very much. This case is been concluded. I'll submit the order to the clerk for filing. Thank you all.
What a great
Thank you.
judge.
Thank
Isn't
you.
it great? Okay. So imagine this judge with this voice coming up. Now, nothing crazy happens in this next video. In this next clip. I'm just showing it because of that voice. That voice. I did it once before, but it's been a while since I played the voice. So I'm going to do a small one, which isn't really that crazy, with the voice. Here he comes.
Hello.
All right, now I can hear you, Mr. Royce.
Thank you.
Then the court will call F352-23. It's in the interest of Royce Wallace. Are you Royce Wallace, sir?
Sure.
Mr. Wallace, my name is Lee Harris. I'm the judge of the district court here in Hill County. I was advised that you had been detained on some warrants, or it's hard for me to tell if it's 1 or 2 warrants out of the state of Mississippi, but appears like it's. There's one case says it's number 201557, and then there's which references a 5-year term for grand larceny, suspended, and you placed on what they call post-release supervision, which I'm assuming is the equivalent of our probation. And then there's another reference in here to a 10-year sentence, suspended and released on 5 years. So I'm not 100% sure if that was a 2-count indictment or something, or what it was, but
That was the same thing.
it was what? I'm sorry.
It was the same thing.
Okay.
He came with a charge.
All right. The couple of things that I need to visit with you about is, first of all, I'm not exactly sure why a person is entitled to a lawyer at this stage of the proceeding here in Texas, but they are. And if you were to tell me that you were indigent, unable to afford an attorney, I would appoint one to represent you. The lawyer would not be representing you in the actual criminal matter, as far as the state of Mississippi is concerned, but they would be representing you to determine whether or not this was a valid warrant. A person has a right to demand what's called formal extradition, which is where a person has the governor of Mississippi send a request to the governor of Texas to honor the warrant there in Hill County. You've signed this waiver of counsel, and what that tells me is that you do not want me to appoint you a lawyer, that you wish to represent yourself in this matter. And then you also sent down a waiver of extradition saying that you didn't want to wait for the state of Mississippi and the governor of Texas to get together and hash all that out, that you just merely wanted to go on back to Mississippi and take care of your business there.
That's right.
Let's talk first about the waiver of lawyer. You understand that if you asked me for a lawyer and told me you were indigent, I would appoint you one. You understand that?
Okay.
But is it your desire to go ahead and just do this on your own here today and see what Mississippi's going to do?
I mean, if it's gonna help me get to Mississippi, like I said, I mean, I don't mind. I ain't no use to me prolong going back to Mississippi because I was on probation.
Okay.
So when ain't no use to me prolonging it anyway because they're gonna eventually come get me anyway.
Yeah. It appears that they will, because they do have a no bond and apparently have determined they would extradite. I'll approve the waiver of counsel and will approve the waiver, or excuse me, the waiver of extradition. I will tell you this, the jail down there will notify Mississippi probably today, and that will get the clock running. I don't remember if it's 10 working days or 15 working days. I think that they can tell you at the jail they keep up with that stuff better than I do. But the state of Mississippi does not have an unlimited amount of time to come get you. If they don't come get you within that time period that the law allows, the jail will let me know, and I will set you a personal recognizance bond for you to be able to bond out. But I have to give the state of Mississippi the opportunity to get here first. But if they don't, I will be allowing you to be released. All right. All right. Well, Mr. Wallace, good luck to you. And if they don't come get you, the jail will let me know.
So I don't have a charge here. Why would I have a bond?
Well, it would be a bond for the state of Mississippi, but it would be a personal recognizance. I know they have said no bond, but that no bond only holds if they come get you within the time period they have to come. That keeps a person from just being held forever in Texas on a Mississippi problem. So the time period should start running today, because as soon as I send this down there, the jail's going to teletype Mississippi and say, you got X amount of time to come get Mr. Wallace, and if you don't, the judge is going to let him out on his own signature.
So my time then started after the holiday?
Your time on the Mississippi coming to get you will start today. Now, as far as if you get a sentence out of Mississippi, it should go back to every day you've been in jail.
I understand. I'm talking about the time I got locked up, even though that was on a Friday, I can't remember. But that Monday was that Christmas, but I know that don't count because I got locked up by 7 o'clock. But after that Christmas, that Tuesday, it was a new week, right?
Right.
So my time don't start from that Tuesday up to.
It just starts as soon as I approve this and send it to Mississippi, because nobody made me aware you were there till today. As soon as I heard about it, I said, well, let me talk to the man. Mm-hmm. So as far as the time for Mississippi to come get you, that starts whenever my signature hits the state of Mississippi, which should be this afternoon.
Because when I got locked up that Friday, and they had to do a fingerprints and blood shot, and I saw a judge here that Saturday.
Right, Judge Brazel.
I don't know his name. He's real young.
Yeah, Judge Brazel.
Mm-hmm. And he was out, and I was telling him, see my office about I want to go ahead and wave my hand, just get extradited back to Mississippi. And she was asking him, how do you go by doing that? And so therefore, I thought I signed it, the paper to go ahead back to Mississippi if they're gonna come get me.
Yeah, unfortunately, that Judge Brazel can't do the waivers of extradition. Only myself or Judge Crane can. If somebody had made me aware of it, I'd have done it the day after I found out.
But I think anyway.
All right, sir. Well, good luck to you, Mr.
Yeah, I don't even know what happened for the last 7 minutes because I was like in a trance. I heard like Mississippi and Judge, but that's all I know. I don't even know if it was a good clip or not. But now I'm awake. I snapped out of my trance. Okay, I got one more. And nothing really crazy happens in this one, but I recorded it because it's almost worse than someone being crazy and angry or obnoxious and crying. She has this smile on her face that's like, I don't know how to describe it, but I'm going to put it on. It's 14 minutes long, so if you want to dip, you know, this is just her. I mean, it doesn't help, but the smile, I think, infuriates people more than if someone was like screaming and angry and, you know, sad and crying.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Ashley Nicole Lakin. It's case number 22 CR 507. Ashley Lakin appears from the Butler County Jail Zoom location. Joseph Favre's defense counsel, Amber Norris on behalf of the state. This is a warrant to show cause matter, probation violation being alleged. In this instance, there is also an addendum for the defendant being arrested for possession of paraphernalia on December the 18th of 2023, as alleged by Christy Ashenfelter, the ISO on the case. Also, she admitted to leaving the state without permission to travel to or reside in Ohio. Ms. Norris, are you aware of any other violations that are being alleged?
No, Your Honor, just the original warrant and then the addendum.
I don't have the original warrant before me.
Your Honor, the original violations have to do with failure to report on August 15th of 2023, and then failure to complete alcohol and drug counseling treatment, and then July 27, 2023, defendant submitted a urine sample positive for ETG, methamphetamine, amphetamine, and fentanyl. And on August 28th of 2023, the defendant failed to admit to inpatient treatment at Miracles.
All right, thank you. Mr. Favre, your client's position on these various allegations?
Judge, Mr. Lakin would admit to the violations in the original and the addendum at this time. I understand this is her first time up, but she's going to stipulate to all those violations. We've discussed those.
All right, Ms. Lakin, your attorney has made an announcement that you now intend to stipulate or agree that you committed these various violations that have been discussed: failing to report, failing to complete treatment, a positive urine sample for meth and fentanyl, failing to go to inpatient treatment when directed to do so, leaving the state without permission, and then the arrest for possession of paraphernalia and not reporting that law enforcement contact. You do have the right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence, confront the state's witnesses unless good cause was shown. And I need to point out to you, among other lesser remedies that the court may consider, the court could consider and impose just having you serve the remaining balance of your sentence locked up in prison. Do you understand these things?
Yes, sir.
And do you waive a hearing in this case and stipulate?
I waive it.
And do you agree that you committed these violations?
Yes, sir.
Very well. Court finds that Ms. Lakin knowingly has waived her right to a hearing and stipulate and agrees that she's committed the violations that have been outlined here on the record. These are substantial and material violations of the terms and conditions of Ashley Lakin's probation, which was for possession of methamphetamine, a level 5 drug felony, sentenced back on July 14 of 2023 to a controlling sentence of 13 months in Department of Corrections custody.
Court will turn to disposition matters at this time. Ms. Norris, on behalf of the state, what are your recommendations regarding an appropriate disposition of this case?
Your Honor, this is defendant's first warrant to show cause. She was placed on probation back in July with up to 18 months supervision with community corrections. We would ask the court that she serve 3 days in the Butler County Jail from today's date as a sanction. She has been in jail since her arrest on this warrant, which was on December 18th. So she does have some jail time credit, which as of today's date, 18 days. But we would ask that she serve a 3-day dip forthwith, and that she continue on community corrections probation with all standard and previously ordered conditions. The court will need to address additional court-appointed attorney's fees and the bid's application fee. And Your Honor, it's my understanding that Ms. Ashenfelter has arranged for an inpatient bed, which is the treatment level apparently that she qualifies for, to begin next week. And so we would be requesting upon her release that she make contact with Ms. Ashenfelter to complete that process.
Very well. Is there anything that you would add to the prosecuting attorney's statement to the court, Ms. Ashenfelter?
No, Your Honor.
All right. Mr. Favre, your recommendations regarding an appropriate disposition?
Judge, Ms. Norris correctly states this is Ms. Lakin's first time up. It has not been a very successful probation thus far, which she clearly would admit. She would note to the court that she has been sober. She has not used substances. She did have a paraphernalia that she was found on her possession in December, but she has not actually used, she claims, since the end of, I think, October, she said. So she has had some sobriety. She wants to go to inpatient treatment, and we'd ask the court to follow the recommendations of giving her a dip and allow her to do that. She still has significant time left on her Senate Bill 123 probation.
Make me wonder, Mr. Favre, why would she have to have drug paraphernalia on her person if she wasn't using?
Judge, I mean, I could only speculate. I mean, my experience dealing with a lot of drug cases is that people that have drug cases tend to leave their paraphernalia a lot of random places, which is the subject of many a drug dog search. So,
I appreciate your speculation, Mr. Favre. Court will turn to the defendant, Ashley Lakin, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court.
It was a marijuana pipe, but I've been clean off meth since about the beginning of September and everything. And where I was at in Ohio, I went out there to get away from the toxic people and the town and everything and to get clean and everything. And when I was ready, I wanted to come back and turn myself in and do the right thing.
All right. Well, I don't think that the court's going to consent to you moving to Ohio. So what happens when you get right back out into the same community where all these people are, Ms. Lakin?
I can be around them now and be able to function as a good citizen and everything like that. I can't be around the toxic people. I put those in my past, but I can be in the community now and to get this taken care of, my 18 months on corrections, and to succeed. I'm ready to do that.
Why weren't you ready when you were sentenced?
I don't know.
I thought that was a pretty serious matter that you probably should have taken seriously at the time.
I know.
But
I
you
know.
didn't.
I just didn't know where to start, really, honestly, in myself. And I had to go find myself and everything. And I did. And I love myself now. And I love myself enough to give myself the right life that I deserve.
I think Mr. Favre referred to your probation thus far as not very successful. It's nothing but unsuccessful.
Yeah. But now I'm ready to be successful.
And quite frankly, Ms. Lakin, if you're going to continue to do methamphetamine and fentanyl, I'd rather stay in prison. You'd have a chance there.
I haven't done any meth since about the end of August, early September.
I really don't know how credible that is.
I'm chunky. Chunky means sober.
I never heard
What did you say?
I said chunky means sober. You know, I've gained a lot of weight and I'm in a better spot, you know, and everything in my life. So I'm ready to do it now.
Ashton Filter, do you agree with this recommendation?
Judge, are you referring to the dip sanction?
Yes.
Recommendation? Your Honor, I believe she's going to have her dip sanction at one point or another, though I would speculate that she should be held in jail until her inpatient bed date.
Well, I think as you can tell, Ms. Lakin, this court has reservations. I just don't want you to kill yourself or completely ruin your life through drug use that I thought we'd addressed with your original sentencing. That obviously didn't take. You say now that you get it and that you're ready to do better. At this point, the court's unconvinced. Nevertheless, I do have some fairly unanimous recommendations before me. The other professionals on this meeting appear to want to give you another chance to either succeed or fail on this community corrections program. I question whether that's really in your best interest.
I think it is.
Well, I'm sure you think it
I don't
is.
want to let him in. I don't want to let nobody down.
Well, it'd be yourself you're letting down.
I haven't let myself, I'm not going to let myself down. I love myself too much.
Court has previously found a number of substantial and material violations of the terms and conditions of community corrections placement. The court will revoke the probation but reinstate it with all original conditions still intact following the service of a 3-day dip sanction in the Butler County Jail. That is a prospective sanction. Therefore, it starts right now. Ms. Lakin, you'll serve 72 more hours in jail and then be released back on community corrections. You are ordered as a condition of probation to immediately contact Christy Ashenfelter at the Community Corrections Department upon your release. Now, that should be sometime on Monday about this time. So you should have plenty of business day left to make contact with the Community Corrections Office. Then follow directions from there regarding placement into inpatient treatment or reporting to the officer or both.
Yes.
Apparently the plan is quickly getting you into an inpatient facility. Now, I don't know how much you need detoxification after spending this stretch of time in jail, but I'm also not going to quarrel that if a professional evaluates you and thinks you still need inpatient treatment, so be it. But I hope you understand, Ms. Lakin, that I'm not going to give you multiple chances after this. I mean, you got one more. Court's empowered to put you in prison next time. And if I have to do that to save you from yourself and from these bad people that you seem to associate yourself with, that's what I'll do. Okay?
Yes, sir.
I'd rather see you do it out, on your own in the community, though.
I do too.
And perhaps treatment will assist you and some aftercare will assist you in doing that.
I hope it will.
Successful completion of inpatient treatment or the treatment that's recommended by appropriate professionals and any aftercare recommendations are specifically made conditions of reinstatement of probation in this case. I don't see a need to extend probation at this juncture. I'm not going to assess any additional fees against Ms. Lakin given her long term of incarceration in jail and the fact that I expect her to enter a treatment program at this current time. When you get out, I expect you to have a job, Ms. Lakin.
Yes, sir.
Okay. All right, Mr. Favre, are you aware of anything else we need to address here?
Not this time, Your Honor.
Ms. Norris, anything further regarding Ashley Lakin?
No, Your Honor, thank you.
Ms. Ashenfelter, do you need any clarification regarding the court's orders?
No, Your Honor.
Ms. Lakin, do you have any questions regarding what we've done here today?
No, sir.
Good luck, Ashley. I hope you make it.
I will do too. Thank you.
All right, I'll remand her back to the custody of the jail officials until she serves 72 more hours and then to be released on this case. That concludes the Lakin matter at this time. We'll move on to another matter on the docket.
hear me, but I think we're done. Yeah, yeah. See, that's why I recorded it, Red Hat, because that smile was like, "Urgh." Put that smile away. You shouldn't be smiling right now. Yeah, it was infuriating, and I don't know why. But she got what she wanted. Maybe that's because she was smiling. I smile all the time, and apparently I'm sober, because chunky means sober. And even though I work at a brewery, oh, I don't know why you couldn't hear it. Giggles. I don't know why. But that's all right. All we cared about is her smile. Her smile was infuriating. Whew, what a night. We had a lot of them. A lot of them. And they were good. See, I had a comment, I think it was yesterday, that I need to put a camera up, but I can't because I laugh at the most inappropriate portions of these videos. And then you guys will be like, whoa, don't laugh at that. That's not funny. So I just can't because I can't help it. I laugh at all of them. Every single one of them makes me laugh, except for the trance I was in because of the voice. But we Frankensteined a whole man here. We took one judge's face onto another judge's voice, and we'll give him Mike Baker's age, which is 40 in my head. So we're gonna keep it there. Watch, he's probably like 29, saying "son of a bitch." No, thank you guys all for coming out. I appreciate it. I really do. I'm going to try to get some Connecticut's tomorrow for you because we never get to see Connecticut. You know, maybe more Indiana. We'll see. The problem getting Indiana's is like, it's like if you try to chase 7 rabbits at one time, you catch none. So like, you can't rewind those. So you have to watch, you have to record and hope it for Indiana. And while you're recording that and hoping, you can't look at anything else. So I don't know. It's like fishing. Sometimes you get good videos. Sometimes you don't. I wish we could get like Karens every day. I just do. They just don't happen. They do though in Simpson and Manning and Webster. I should start recording them, but everybody records them. But they have such great content though, don't they? No, I think I'm gonna stick with what I'm doing. Well, thanks for coming out. It's only 10 o'clock, almost 11, so I'm not gonna tell you to go to bed. You can stay up, and I will talk to you next time. Have a great night, guys. Bye.